We are now ready for the case of Sioux City Truck Sales versus Iowa Department of Transportation and Peterbilt Motors and Allstate Peterbilt of Clear Lake. It's my understanding, Ms. Rabe, that you and Mr. Clouatre will be sharing time? Yes. I'll let you guys be in charge of divvying that time up. Thank you. You may proceed.
May it please the court, counsel. Thank you for the opportunity to be here today again. I appreciate that. Context matters. It matters in both our personal and professional communications, and arguably nowhere does it matter more than in the interpretation and application of statutory law. The issue today before this honorable court is the definition and context of the word community in connection with Iowa Code Section 322A.16. Specifically at issue is the use of the modifier that, which precedes the word community in 4 of those 6 subsections. If I may just give the court a little bit of background on the case. In August of 2017, Peterbilt Motors applied to the DOT seeking the appointment of Allstate as an additional dealer franchise to serve the 23 county area that it had identified as the Clear Lake area, which would create an area of dual assignment between Sioux City Truck Sales and Allstate, and Allstate would be the new franchisee. Peterbilt had identified this as an underserved area going as far back as 2012, being a major point along I-35 and with the nearest Peterbilt dealerships over 100 miles away. They had repeatedly negotiated with Sioux City Truck Sales to bring a full-service Peterbilt dealership into the area. That had not been successful. In fact, the record indicates that it was the opinion of the lower tribunals that Sioux City Truck Sales had not taken any meaningful action to make that happen. So in 2016, Peterbilt began taking the appropriate legal steps to add an additional franchise to this area, which would create an area of dual assignment between Sioux City Truck Sales and Allstate Peterbilt. These steps included notifying the DOT of its intent as required under Iowa Code Chapter 322A. And when Sioux City Truck Sales objected, a contested case hearing was held, which is an automatic occurrence in these situations, to determine whether or not there is good cause for Peterbilt to enter into a new dealership in that area. So herein lies the issue that brings us all here today. It's the definition and the interpretation of the word community in the good cause analysis of Code Section 322A.16. It is the DOT's position, as it was the district courts, the agencies, and the ALJ, that the term that community, as a quote, for determining is what you must use to determine the appropriate basis for the statutory evaluation of good cause. And that in this case, that community means the 23 area identified as the relevant area to the Clear Lake region, not the 71 county area, which is the entire Iowa area that Sioux City Truck Sales has investments and operations in, as well as they do a large amount of business in Nebraska, which was also included in their original franchise agreement. 321A, subsection 2 defines community as the franchisee's area of responsibility as stipulated in the franchise. That is not at issue here, nor is what constituted the area of responsibility in the original franchise agreements, many of which go back to almost exactly the time that the Iowa Motor Vehicle Act was enacted in 1970 or slightly before. So these are 50-some-year-old agreements at this point. But 322A.16, importantly, doesn't just contain the word community. The simple word of that, which precedes community, is central to this case. 322A.1 provides in this chapter that the statutory terms are controlling unless the context requires otherwise. Here, the context clearly requires The context clearly requires otherwise, and this is where the Court of Appeals erred in reversing the lower tribunals and not considering the context of the word community as applied to this case. DOT is called upon to administer Iowa Code Chapter 322A to determine whether consumers have adequate access to dealer services in a defined community. That was part of this court's holding in the Craig Foster Ford case. The legislature was not concerned with locations where there would be no dual assignment, and neither is DOT. The DOT's role in overseeing this is to make sure that communities and consumers of Iowa are adequately served in a state where we have 99 counties, many of them rural, and many of them away from larger metropolitan areas and sparsely populated. If the Court of Appeals of interpretation of community stands as a practical matter, there is no way for an additional franchise to ever be added where the franchisee has multiple locations across Iowa, or even, as in this case, in multiple states.
Statute that applies, not just to trucks like this case involves, but car dealers, right? Is this a situation that is typical of car dealers, that you would have a car dealer that is operating in multiple, kind of many metropolitan areas? Is that common?
I think with car dealerships, I haven't seen it, and I think it's far more likely to occur with a trucking operation, because by their nature and investment and expense, they're not going to be as common as your neighborhood, Chevrolet dealership or Ford dealership. They are more of a specialized dealership.
Isn't this really kind of a statute to protect dealers? Isn't that what it's really about?
Really been identified historically as having two purposes, both, I think, as this court noted in the Midwest Auto case, that it protects the dealers to some extent, and is certainly may have something to do with dealer competition. It's also meant to protect the public and ensure adequate consumer access to particularly to service.
We don't have a statute that requires grocery stores or protects grocery stores or stores that sell home appliances or anything like that. We rely on normally in this country, we rely on the free market. In this case, there's sort of a privilege given if you're an incumbent dealer, right? Isn't that how it works?
I think with the creation of the chapter in the Iowa Motor Vehicle Act of 1970, that was the intent. I'm not aware of anything similar as you've mentioned that would have to do with grocery stores or any other retail establishment.
He said, and maybe I misunderstood, that under the Court of Appeals standard, it would be hard or maybe impossible to establish good cause. And I'm not sure, that's not a foregone conclusion, is it? You could still establish good cause even with a broader reading of the word community, right?
But I think it's going to be a very difficult legal hurdle, because in this case, if your 71 county area includes Des Moines, Sioux City, Council Bluffs, and also parts of Nebraska, which is an entirely different issue, because how do we look at the business they're conducting in Nebraska as being relevant at all to what would serve Iowa's consumers, and in this case, northern Iowa's consumers? If you're looking at the entire region, in this case, 71 of our 99 counties, how are you ever going to then identify the Clear Lake area as meeting the good cause definition of needing an additional dealership? It might be common sense. You can look at that area and see that it's underserved, but how are you going to meet the statutory burden of showing good cause for that area if you're looking at the dealer's investment in the entire area as a whole? It only makes sense in reading and applying this statute to look at the impact the new dealership would have in the area where the dual assignment is proposed. particularly where all the parties are in agreement in this case that the Clear Lake area was underserved for.
So it might make sense, but is it required? That's sort of the word that I'm getting hung up on in 322A1. I get that it might make sense. It might be better, you know, in terms of competition, of serving the public. But do we have to read it in that fashion?
DOT's position that that's the only way to read the statute that makes sense. Because if you don't read it in context of just the area where the dual assignment is going to occur, then it doesn't, the purpose of the statute in looking at the good cause factors doesn't make sense. It doesn't make sense to evaluate the large metro area of Des Moines when looking at whether or not Clear Lake or Algona or Humboldt has a need for an additional franchise of the same line make. And remember, we're just looking at areas where there's would be a dual assignment. We're not looking at areas, if Clear Lake was not part of the area of dual assignment, if there was, you know, if that was not included in this 71 county area of responsibility that Sioux City Truck Sales has, then it wouldn't be an issue. It kind of goes back to what's the area of responsibility. And if you're going to define community strictly as the area of responsibility under 321A1, I think the legislature has recognized that can lead to an absurd result when you have a large area. And I believe that's why they specifically said, unless the context requires otherwise.
Doesn't that place on us some view of what's too big and too small? So couldn't I make the same argument about North Des Moines and the south side and the east side and the west side, right? Instead of Des Moines versus Clear Lake? I mean, isn't there some sort of sense of we would have to make some call as to a geographic area, what's too big or?
When, you know, that would be a call that someone would have to make. I know in this case, it was Peterbilt that decided, you know, that the Clear Lake area constituted the 23 counties surrounding it. But I think you also get to a point where that would sort of defy common sense. You aren't going to say that the Polk County, Des Moines area is that ends right at the, I mean, nobody's saying it ends right at the line, or I mean, I think you have to look at the geographical area, the number of other dealers there.
And I guess I'm going to call it the subdivision problem. If you subdivide an area into the county or the region you think that's relevant, so let's say you take this 23 county service area now, and 5 years from now, you look at the 23 counties, you find the one that's most underserved, and then you say, okay, well, now we're doing a new dealership for this county, because if you look at the service in this county, it's not adequate. So, I mean, that would fit with your definition, right? Because that's the community you're looking at for now, that dual member agreement.
Identified as that community. And in this case, that community was defined at the time the plan was presented to DOT as the 23 areas surrounding Clear Lake.
Another plan 5 years from now that says that community is a single county within this 23 county region previously, then for that analysis, it's that county that's at issue under your reading of the statute, right?
County, it would be what constitutes that community. So you would have to look at the term.
What, you know, I have a side hustle teaching antitrust at Drake. So you're talking about something that maybe in terms of a relevant geographic market. In other words, so you would define community in terms of where somebody would reasonably turn who needs to get their truck serviced and repaired. And your point is somebody up in Clear Lake isn't going to go to Council Bluffs to get their truck repaired. An owner-operator in Clear Lake is not going to go all the way to Council Bluffs.
It's that you have to look at community in terms of where the service is available and where the impact on the consumer, making sure that that needs met. And
Sorry. Isn't the answer then to sort of shrink the franchisee's area? I mean, isn't that sort of the answer, that you just don't want to get too big on those because you might be boxed in later? If you want to,
Mr. Clouatre is present. He is Peterbilt's counsel. I have eaten up most of the time, so I will give him the rebuttal. But I think that's something that is between the franchisor and the franchisee at the time they're entering into these agreements. And that's not the DOT's concern, because our concern is coming in when there's an alteration or a discontinuation to make sure that we can apply the provisions of 322A16. And we're kind of stuck at that point with what the parties have agreed on previously to that. Thank you very much. My time is up, I see, so.
It's confusing.
20 seconds, but it's going up.
27, yep. Yeah, thank you. It's my understanding that Mr. Goldstein will be arguing for the, for Sioux City Truck.
Chief Judge Christensen, the panel, counsel. I think the key word in this case right now is not community. It's the word require. That was pointed out earlier in 322A1. It says where the context otherwise requires. It doesn't say suggest.
That before community require a different context?
Runner. The 322A16 requires factors, 16 factors, 6 factors, and the word that goes back to 322A4. There are piers set up in this statute, 2 pieces that go with a termination, a non-continuance, an alteration of territory, and then an additional franchise dealership.
Whole dispute arose. Your client didn't go to Peterbilt and say, Peterbilt's complaining about what you're doing in the Clear Lake area, and you didn't go back and say, hey, we're doing a great job. We've got great investment in Council Bluffs. We're doing there's a lot of business. We're transacting in Council Bluffs. Our investment in Council Bluffs is permanent. I mean, you didn't view that as at all relevant, did you? But now you say it is relevant.
Viewed it as relevant at that point, Your Honor. That was one of the reasons why they concluded the courts below that we didn't have a desire at that time to move forward. The record shows $25 million of investment. And as the court pointed out, Peterbilt put all these counties into one dealership agreement. Peterbilt could have put 3 counties, 4 counties. This was their option.
Change. I mean, Iowa is a significant trucking state. I mean, we've got 80 and 35 converging, and what might be the state of the market, 20 years ago, 40 years ago, isn't today. And you're saying it's just frozen in time, right?
Under this statute, the statute is what it is. The community appears 35 times, 34 times. It's defined. There's no reason to move from that. There's no absurdity, as counsel has suggests, if you use the full community. They're easily applied. And I would say to Your Honor that if they really wanted that community that they negotiated with my client to have all those counties, and my client was spending $10 million someplace else, and they wanted that to open something, my client wasn't ready, they could have either funded them or bought the territory. This isn't as though things are frozen in time. It's frozen based on Peterbilt's having agreed to those counties with my client. In the future, if you were a car dealer or a truck dealer, you're going to look in and see a decision if it's affirmed, and the car dealer is going to say, hey, in Iowa, we cannot put 20, 50 counties into your franchise agreement because it's interpreted as the area of responsibility, and it easily resolves itself. I don't think that's a problem whatsoever. And also, I think, Your Honor, under those 6 prongs in 322A16, it was suggested here earlier, can't you go back and still win and show good cause? Of course. Those last 3 prongs, the public interest, the retail in the industry, those can take in so many factors that they want to bring in. They want these factors brought in on factors 1, 2, and 3 so that there's absolutely no chance. There's no definition. They want you to make an exception for the definition that exists up front.
About if they don't like what's going on in Clear Lake, they can buy the rights to Clear Lake from your client. But then that expense has to be recouped from consumers. How is that in the interest of consumers?
This problem has to do with the failure to recognize in the pleadings, in the argument, that this is a statute with dual purposes. It's very complicated. There are the franchisees, the individual dealerships, 1970. That was a big time. Car dealerships and truck dealerships getting protection for unfair practices. And the legislature, unlike some other states, also said we're going to protect the public. There are 2 components. When you look through the 6 prongs on 322A16, you can see an incredible melt of all factors, pro what I'd call dealership factors and pro public factors. There's no way to tell how the agency would necessarily a priori balance those. It's going to be a factual analysis. If we went the other direction, we would have an open-ended definition of community only for one separate section in the statute. And not only that, but what's that going to say for statutory interpretation? This is a tough area in Iowa. When you read back, when you're out of state and look at all these cases, it's very difficult to discern immediately what is the proper criterion or how they're balanced. What I've been able to determine is you look for ambiguity first. If there's no ambiguity and it's defined by statute, that's the end of the program. That should have been the end of the program. The judge and the district court started looking at syntax. There was no analysis whatsoever. DOT did no analysis. All it said was, we think it's logical. And with all due respect to counsel, she stood up here today and said that it was common sense and logical, and that's why you should reject a written definition.
In most situations with a car dealership, usually you're not going to have the community, the franchise area is going to be somewhat analogous to what economists would call a geographic market. Here it seems like it extends far beyond what would be a geographic market. So that you're looking at factors that really are irrelevant to the market at issue, which is Clear Lake, in order to decide what you're going to do in Clear Lake. And that seems to me anti-consumer. It might, you're right, it may be what the legislature wanted. It may benefit your client. I think it benefits your client, but it's anti-consumer, and that's what troubles me about it.
Have a problem, with all due respect, you'd have a problem with the entire statute to the extent.
Probably do if I were in the legislature, but I'm not. So you're right, I'm bound by the statute. You're absolutely right.
I understand the concern. There are dual bounces, and they're almost many times, 80% of the time, in direct conflict. Then you've got the antitrust laws going from early Reaganomics, all of a sudden going to consumer welfare, and it used to be focused on the competitor. So I do understand that tension, but the tension is an inherent part of the statute because it's dual purpose.
At the risk of confusion, introducing another concept, but the statute seems to be oriented toward what I will call encroachment. Encroachment meaning a franchisee has a particular market area, and then, oh my golly, another franchisee comes in the same market and you eat each other up. And the existing franchisee or the prior franchisee made investment and all this kind of stuff, goodwill, et cetera. And all of a sudden, after 20 years of working, looks across the street and there's Peterbilt, let's just say. All right. But But that seems to be true in the area of competition. But in Nebraska, how is that germane to the encroachment problem where you have two people eating each other up?
I think it goes back to what I said initially. 322A16, there are 6 prongs. 3, as I look at it, focus on one of the goals, which is focus on the franchisee. 3, focus on the consumer. So the question of the investment, which you're getting at, and why would that matter if it was out in the other side of the state or Nebraska? The fact is that the investment made by that franchisee in reliance on the franchise agreement, in reliance on the statute, okay, that is a franchisee issue. He's still made that investment. Now, your question, does something at the other side of the state does that investment affect the guy in Clear Lake? Probably not. But those factors that are in 322A16 allow that to be taken into account. It doesn't militate, as is required here, the court to totally scuttle any type of statutory analysis that's established on the books, which is a little bit gray, I think, with all due respect. And
We're communicating. This is helpful. The first factor, amount of business transacted within the community. Let's assume, and I have no idea what the marketing data would show, but let's assume in Council Bluffs you had just a huge market, and sales are going up double digits for the last 10 years. And then your market declines, and then by the time you get up to Clear Lake, it's 0. What's the relationship between that very large investment in Council Bluffs, which has tens of thousands of clients, let's just say, and the Clear Lake area, once again, where there's no market overlap, and it's just...
okay. Here's, I think, the problem with the assumption, with all due respect. Again, I think you've got to look at each of the factors and understand that they come from a dual purpose. So if you only looked at consumer welfare, which antitrust, then you're going to come out one way. And if you only looked at consumer welfare, I would think you still have a problem in this case because of your statutory interpretation as you've developed by common law. It says where the context otherwise requires. You start out with that. I don't think it's required. They may not like the outcome, and I think they indicated they don't like the new balancing that may take place. The new balancing is going to give everybody a fair shake. It's a different shake. But to give them a fair shake, they want to wipe out the first 3 factors as it's explicitly defined in the statute. I think the court has faced cases where it's explicitly defined in the statute, and there has to be overwhelming absurdity to use that defined term before the court will overrule that and count it out or redefine. There's no absurdity. All there is applying those factors so that they reflect some protection for the franchisee. And that would be his investment. And that would be the amount of money he's invested.
Maybe this, and I'm just exploring it with you, and I appreciate, your indulgence. Supposing we include the whole 71 county area, and DOT says, okay, first factor again, amount of business transacted, and we have the Council Bluffs issue like I had before, a hugely successful business. But, so the amount of business is quite high, but it's not impacted by this new dual dealership, so I marked that factor down to 0. And then I go to number 2, investment. The investment is, I'll say, $25 million. Very substantial investment over in Council Bluffs. What impact will the Clear Lake dual representation have on the $25 million? 0. So I put a 0 down. And then permanency of investment, I might say, well, yeah, I mean, it's all real estate and fixed costs, but it won't be impacted. And so I marked that to 0. Would that be a permissible approach to those 3 factors?
That's what they're requesting that the court do, which is to read out the explicit definition of community. They're saying if you use the smaller, then you're going to get 0, 0, 0, as you just used.
Then why do we consider these factors if they have absolutely no impact on the transaction?
It's not the question of the transaction. It's a question of the impact it has on making the dealer, protecting the dealer's fair rights. So there's two goals. That wouldn't affect, the second goal is access by the public, consumer welfare and things of that nature. And the other one is how much this guy, my client, has put out of his pocket, and the record shows 25 mil. So how does all this get resolved? Peterbilt should not have negotiated for, who knows what that deal was. It was a free market deal. We bought X counties for X amount, and they gave us, and we had a right. We had obligations in those counties. They knew what that was. If this court were to affirm, the Court of Appeals, then car dealers with all the counsel out here, and they're great, all the counsel will look and say from now on the dealership counties are going to be smaller in states that have this kind of definition. But if there's no absurdity of applying the factors. There's not absurdity under the common law, and there's not, I mean, I think what's troubling the court is looking at the statutory purpose. I think you may have leaped too quickly. I think where there's a explicit definition.
Statutory purpose includes the ability of a successful franchisee to exclude development of an underserved market because of past investment.
In common parlance, yes, if it sometimes, but I think that in this case, if it went back to the DOT, they would take that into account. That would be one of the factors under the last three factors. We're not saying jettison it. We're saying give the words their explicit meaning that's in the statute. There's nothing that they presented that requires a different change here. You may disagree with the new balancing. Okay, you can have a consumer welfare versus an individual competitor program, but it's not impossible to apply. And interestingly enough, the AL, oh, I'm sorry, interestingly enough, the ALJ was unable to apply the two factors with any, except for an afterthought. He couldn't figure out how it would apply even to the 23 counties. So using their analysis, you've got to, yes, I'm sorry. Thank you, Your Honors, and I guess I'm done for the day. Thank you.
I'm not sure if I'm pronouncing that correctly.
Good afternoon, Chief Justice and Justices. May it please the court. If I may I start with talking about the investment? It was just recently said and thrown out a couple times that the investment was $25 million. And that's from, I'd encourage you to look at it, it's App 20. And it lists the investments made by the dealer since 1971, so approximately 48 years period at the time of the hearing. And over half of that investment was made in Nebraska. Now, how that helps an Iowa consumer in Clear Lake is I think, at the heart of this dispute. And the dealer principal admitted that zero was invested in Clear Lake. So again, Ms. Rabe referred to a 4 or 5 year period where Peterbilt was going back to the till to the dealer, please go to Clear Lake. Here's summaries and here's studies showing why we need a dealer in this hole in our market. And the dealer opted to do nothing. And so that's when dealer came up to the dealer and gave him the notice of dual assignment. And that dual assignment is carefully calculated. It's not something that's thrown at the wall. Those counties were selected scientifically based on the census tract and the centroids of those. So it's scientific and it's not something ambiguous. Yes, sir.
The statute come before the deal between Peterbilt and Sioux City Truck? Was it statute then agreement, or agreement and then statute?
Short answer is, I don't know the answer to that question. It was right at the same time back in the early 70s. And I'd like to clarify something about the dealer agreement. The dealer agreement is with a parent company called Sioux City Truck Sales. Then there's 5 or 6 addendum particular to each DBA. So Sioux City Truck Sales of Council Bluffs, of Norfolk, of Lincoln. And for each of those addendum, there's assigned geographies as to each of those dealerships. So to conglomerate all of them into saying 71 counties in Iowa plus X number in Nebraska plus about 2 or 3 in South Dakota, and treat that as a community is actually not following the contractual language. The Des Moines dealer agreement actually contained the Clear Lake geography at issue. So I'm a little confused by this argument from the get-go. The dealer didn't even raise this during the hearing. It was raised briefly in pre-hearing briefing. It was not raised in post-hearing briefing before the ALJ. And then it was raised on appeal with the district court for the first time.
Covers Clear Lake.
Would have been the Altoona, well, it was the Des Moines. And it's actually the Altoona AOR, or Area of Responsibility. That term was referred to earlier.
At that point, so is there more than one area of responsibility as used in the statute within the franchise agreement?
The dealer would like you to believe that it's just one big conglomerate. In actuality, each of the dealers are assigned separate geographies in each of the separate addendum that's applicable to the DBA.
Guys?
There is one. And it's an interesting point because I've heard about it's Peterbilt's fault for coming up with this huge geography. Well, actually, dealers decide how they want to organize their own corporations. And that was the way that this particular dealer group decided to organize.
One franchise with that conglomerate.
Yes.
Sign off on those? Can the DOT say that's too big, we want it smaller because we want to protect folks else? No.
And that's just a private contract between parties. And I believe Justice Mansfield referred to the car dealers. Car dealers' dealer agreements are different in the sense that their geographies are much smaller. I mean, if you think about the number of Starbucks on each corner, or the number of Chevy dealers versus the number of heavy truck dealers you see. You don't see heavy truck dealers on every street corner like you do Chevy or Ford or Toyota.
This question. Opposing counsel points out that there are 2 purposes to the statute. One is kind of consumer protection. But there's another aspect to it that might be characterized as dealer protection. And I think I'm going to recharacterize the claim a little bit, but the existing franchisee has made an investment of X number of dollars and so forth and so on in reliance on the larger area. And so the purpose, although there is a consumer protection purpose that all this economic stuff we've been talking about serves, there's also a purpose of protecting investment expectations of existing franchises.
I call it special legislation, but in this context, in this case, the record is clear that this dealer was given years and years of opportunity to go into the Clear Lake market, being begged to do so and refusing to do so. Yet admitting at trial that he too believed that there should be a point there because there was a need for it. I see that I'm out of time. Thank you.
Sales versus Iowa Department of Transportation and Peterbilt Motors is hereby submitted. Court is adjourned for the afternoon.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.